Okay, very good. So I am very happy to be with you this evening. We have a wonderful special guest who is the Nathan Patz Professor of Law at the University of Maryland. And I would have to say that she has written a fabulous paper, which is just a draft at this point, but she's going to talk to us about hierarchy and race in human rights. It's a fabulous conversation that I suspect that we're about to have. So with that, let me turn this show over to the Dean, Dean Rizwan. Why don't you give us some introductory remarks?
Thank you, Cynthia. Good morning, good afternoon, or good evening, depending on wherever you are. On behalf of the School of Humanities and Social Sciences, Department of North South University, it is my utmost pleasure to welcome you to this webinar. As my colleague Cynthia has said, I have had the pleasure of reading, I would say, a wonderful paper, a wonderful draft, which I'm sure would be published in one of the leading law journals. There's no doubt about that. In her provocative paper, our today's speaker has challenged the traditional discourse on human rights. The mainstream scholarship would often have a very simplistic explanation of the origin of human rights. More often than not, the discourse would tell us that it is during and the aftermath of the Second World War that the European colonizers, they thought that there has to be some sort of human rights which would be universally applicable to all human beings, irrespective of race, color, place of birth, or anything, just because these are inalienable rights. But in a very, I would say, thorough and meticulous way, Professor Sirleaf has challenged this simplistic origin. And she has very boldly argued that many of the canons of human rights and the explanation of its origin is anti-Black, and sometimes it glorifies the colonizers, and it gives a perverted picture, often projecting that the colonizers or some of their practices put some significant impetus to the movement of human rights. She has cited many examples. I would just mention one brief example of a case of the 18th century England, the Somerset case, which took a very minimalist approach, but nonetheless that has been hailed by some scholars as contributing to the journey of human rights. And more damningly, I think, the struggle of the subaltern people, the Black people and other subaltern people, have often been ignored in the mainstream scholarship. And she reminds us that the emancipatory struggle of the Black people and the other subaltern people were not driven just by some idealistic objectives. They had material objectives. They wanted to accomplish certain things for themselves. So, with those few words, I would once again invite you to listen to our today's distinguished speaker. And I'm sure that this work would feature as an essential reading of many 12 or the third world approaches to international law course. If I were to develop a course, maybe in coming years here at North South University, surely her paper would be on my essential reading list. Thank you all. Thank you to our distinguished speaker. Over to you, Cynthia.
Well, thank you, Dean. And with those words, we have to get to our very special star guest, Matiangay Sirleaf. Professor, take it away.
Oh my goodness. Thank you all. I'm so very excited to be in conversation with you. I should say good morning, good afternoon, good night. Well, hopefully not good night just yet. Good evening. Hopefully you'll stay with me before nightfall on your end. But I am just really honored to be in conversation with you all today about a topic that is really near and dear to my heart. And I should say that this paper is a sort of opening salvo to a larger book project. And so the book project is called Reclaiming Our Time in Human Rights. Actually, the full title is that there are Black people in the past, reclaiming our time in human rights, and it's going to be forthcoming with Cambridge University Press. And so what you all had for today is sort of a starter to that conversation called Hierarchy in Human Rights. And you see this installation, an artist in Pittsburgh in the US had this installation, this billboard that she put up. And her work is in the tradition of a number of Afrofuturists who are sort of radically trying to assert the presence of Black peoples in the future. And I am in conversation with her and others in terms of thinking about Black people's position as subjects and in antagonism to Black people's position as subjects, but thinking about Black people as agents, right? As Black people as subjects who were moving, who were thinking, who were doing, and not as sort of objects as the canon presents itself. And so recently you might have heard that the United Nations proclaimed 2015 to 2024 as the International Decade for People of African Descent, to recognize that our human rights must be promoted, must be protected. And my work is aimed at uncovering African descendant people's contributions to human rights histories, because it can clarify, as your dean just mentioned, the evolution of human rights, and also help to uplift the early rights claims of other groups. And so to begin, when we think about human rights history, we start in the main with thinking about the Universal Declaration of Human Rights, which comes to being in the 1940s, and it gets presented in the canon as sort of this foundational moment in the international order where these universal rights claims are made, and then they are, from that sort of proclamation, we get the development of treaty laws to try to implement those rights. And one of the things that I think my project does, and it starts off with this really, I think, important quote to think about from Anthony Farley, is that the rules, as he said, this legal scholar, Anthony Farley, he said, the rules regarding equality and freedom would not be required were the dispossessed not marked for dispossession. The dispossessed would have no motive to imagine rules for equality and freedom. Rules for equality and freedom are nonsensical, where all is held in common. They are imaginable only from a situation of dispossession. If the habit of hatred were not widespread and institutionalized, then the dispossessed would not need to imagine rules for equality and freedom, because one need not imagine what one already is, in fact. And this is a really powerful sort of opening way to sort of think about the issues at the heart of this paper, right? In terms of centering race, centering empire, centering hierarchy in thinking about human rights. And what we find when we look at both human rights scholarship and human rights sort of practice and human rights teaching is a way in which Black people's rights claims and their priorities, which are expressed long before the 1940s, long before we see the Universal Declaration of Human Rights come into being, don't feature in the canon, don't feature largely in sort of understanding both how we think about human rights, how we think about what it means to be human, and the like. And so this practice needs to be disrupted, both in scholarship and pedagogy. And my forthcoming book project is aimed at doing that. And this article, when it comes out, is going to be, hopefully, as your dean mentioned, required reading. Because what I want to do is disrupt what Toni Morrison has termed the master narrative. Morrison defined this as white male life. The master narrative is whatever ideological script that is being imposed by the people in authority on everybody else. The master fiction history, it has a certain point of view. And so how do we think about history? Right now you see an image of the Zanj rebellion in 869 AD of enslaved East Africans uprising. And I'd like to begin with this because what is clear is that those who were facing subordination resisted their subordination early and often. However, when we look at human rights pedagogy and human rights scholarship, it is as if those who were subordinated sort of were waiting around to be rescued by the ones who were doing the subordination. And because a number of peoples were not able to express their claims for freedom, for emancipation, through the means and levers of international law, for reasons which I'll explain in a little bit, they used the means that they could, which were outside of the law. So if we look then to only what the law provided, or only sort of, again, legal texts or declarations, we are not likely to find rights claims. But if we look and understand rights claims in a more sort of fulsome way, to include rebellion, uprisings, revolutions, resistance, both individual and collective, if we think about writing in literature, in poetry, in songs, where people were expressing their ideas for freedom outside of sort of what the legal regime provided, then we might actually have a more fulsome understanding of what rights claims are. In the US, in the Americas, the first documented rebellion of enslaved peoples took place in 1526. And the way in which the human rights canon functions is to do this reverse narrative, which centers those who were involved in enslavement and benefiting from enslavement as the liberators. The law gets presented as the liberator. The enslaving nations get presented as the ones who we are to understand where freedom comes from. Their constitutions are centered in our scholarship and in our pedagogy for us to understand the meaning of rights. And there is this redemptive arc that Mikhail Matua and others have argued that human rights is playing. And it does this in insidious ways because it decenters the actions of subjugated peoples to free themselves and presents it as if rights claims and the expansion of rights happened at the largesse of colonizing powers, enslaving powers, and it was their sort of visions through the Enlightenment and what have you that led us to freedom. So we have a perverse understanding of struggles for freedom. Those struggles for freedom are not tied to sort of rights claims from the subaltern. And we have to disturb and disrupt those foundational mythologies about human rights, because in essence, that reflects a racial hierarchy that's embedded within human rights. And so despite its ambitions, human rights as a field doesn't escape the structural limitations, I argue, and racial hierarchies that are imposed by the larger field of international law. International law, in fact, entrenched the subaltern positions of many Black, Indigenous, and other subaltern peoples who lack lawmaking power nationally, regionally, or internationally, historically, and they were not able to easily translate their rights priorities into law at the global level. Notwithstanding this, the human rights canon exacerbates this hierarchy through adopting legal positivist methodologies that focus how and why the powerful enacted various rights into law domestically, into their constitutions or statutes, or regionally and internationally in international treaty law and international customary law. But if we look exclusively at what the powerful were able to enact, we have a both constrained and shallow vision of rights. And so the battle for human rights is one that is important. And we should think about this in the context of the undemocratic and oppressive nature of how international law has been made historically. And then we should understand that what does get included tells us part of the story, but more importantly, what doesn't get included is as important, right? Which right priorities do we not see incorporated into law, and for what reasons? And so disturbingly, when we think about the early right priorities from Black peoples, challenging the relegation to the status of property, resisting the denigration to being subhuman, rejecting racial subordination, these are quintessential rights claims. But they don't register as such in the canon. Instead, the work of abolitionists who are non-Black abolitionists get prioritized, right? So it is the British abolitionists and the Somerset case, as your Dean mentioned, that gets written about in the canon. So it's not individual people's and collections and groups of people's actions towards freedom that are centered. It is the role that the law has played in furthering liberation, when in fact, the law has played a fundamental role in furthering subordination. We know that from cases like Dred Scott, where the US Supreme Court was very clear that the Black man had no rights that the law was bound to respect. And there is this main character syndrome, which then centers legal institutions from within the global north, their constitutions, the places to understand the meaning of rights and rights struggles, even when those constitutions on their face were fundamentally hierarchically based and did not understand equality in any fulsome way. And so thinking about how even the abolition of slavery gets told from the viewpoint of not those who were working to free themselves, but from the enslaving nations that benefited from slavery and their sort of social organizing, we see the way in which human rights furthers the master narrative at Toni Morrison has talked about in another context in her book, thinking about the bluest eye and referring to Pecola Breedlove and thinking about how you get this sense of unworthiness from everywhere. And so my work then is analyzing how human rights genealogy problematically furthers the master narrative. And I want to demonstrate that to you with a couple of examples. And then I'm going to conclude by thinking about why it's necessary to disrupt this tendency. So first, I want to talk a little bit about the doctrine of sources in international law, which seems like not an important place to begin. But if we think about, for example, Haiti, right? So the Haitian Revolution from 1791 to 1804, in the Haitian Constitution, one of the first constitutions to outlaw slavery in 1804, The only country to self-liberate itself from enslavement, you would think that Haiti would be actually the place that would have a more prominent role. Let me put it that way. Would have a much more prominent role in sort of human rights origin narratives in terms of understanding sort of rights claims, rights making, and the like. And instead, Haiti and its constitution are sort of invisibilized from thinking about rights claims and lawmaking. And so I want to talk about the doctrine of sources here and how it then perfects racial hierarchy. Because again, conventionally, international law provides that only states can make binding law. They can do so either through treaty or through custom. Treaties, as you all likely know, are essentially contracts between states. Custom is based on the general behavior of states out of a sense of a legal obligation to behave in a certain way. Both of these primary sources of law are only made to states, are only made by states. And what is important here is that international law excluded which peoples could be states. And so many subaltern peoples were not even recognized as states. Their polities, their ways of being, their forms of governance were not recognized under the reality of imperialism. And so those that were inside the quote unquote family of civilized nations are the ones who created law. Subaltern peoples around the globe were excluded from the lawmaking project internationally. Many were subordinated in colonies. And even after independence, international law, treaty law, and customary international law is hard to change. And so when we think about the experience of African descendant peoples, the transatlantic trade in enslaved Africans and colonialism created sizable communities of people of African descent across many nations. And then combining that with racial apartheid internally in a number of states and the existing geopolitical hierarchies, Black peoples then, their lawmaking power has been severely restricted and diluted. And so both of the primary sources of lawmaking internationally are ones that Black and other subaltern peoples under colonial rule and or foreign occupation didn't generally have access to make historically or have a say in creating. And even after independence, found it really hard to change law. Haiti is an example of a country of peoples that liberated themselves early in 1804. They were made to pay for their liberation. In fact, they were made to pay reparations to France, France which had enslaved Haitians. And so we already see through the example of Haiti how, and then it is the French Declaration of the Rights of Man that is touted within human rights pedagogy as, a foundational source, right? It's not the Haitian Constitution and the rights claims made in that. Thinking again now about the role that international law is playing in terms of how we think about sources is international law has this principle of general principles of law recognized by quote unquote civilized nations that still is present in the National Court of Justice's statute. And that principle talks about how you look at legal practices within systems that are considered civilized to figure out substantive rules and procedural rules. And although the provision doesn't say so explicitly, well, actually it does. It talks about the civilizing nations, right? So it explicitly on its face is embedding hierarchy. And then the final subsidiary source is talking about judicial decisions and teachings of the most highly qualified publicists of various nations. And that source isn't explicit in embedding hierarchy, but it is implicitly doing so because there is a way in which the nations that are deemed to have the most highly qualified publicists also correspond with colonizing and former colonizing places. And so where we are to understand our sources of authority, again, is not places like Haiti's early constitution and other claims, but in other places. And those places are the ones where we have the places of empire. So there is a redemption arc for empire, and there is a marginalizing of subaltern people's movements toward freedom, which is replete throughout the canon. And we see that through just thinking about Haiti. We see that also when we think about the early Liberian Republic. Their constitution, founded in 1845, was a constitution that was created with the former settlers, formerly enslaved people who were fleeing the United States and its history, an ongoing history of racial violence and terror, and were going to the African continent, and they settled in a land called Liberia. And doing that in conjunction with the American Colonization Society, which was trying to get rid of a free Black population within the United States, they created a republic, which ended up mirroring the settler colonial foundations of the United States, but doing so in Africa, such that when we think about the rights claims within the Liberian Constitution, there was a second-class citizenship given to Indigenous Africans. Indigenous Africans were not allowed to own property. Indigenous Africans were not allowed to vote until the 1945 Constitution. And so there is an attempt to disrupt hierarchy within the Liberian Constitution, but it is placing those who are most adjacent to sort of whatever civilizational ethos from the United States at the top of that hierarchy, and then placing Indigenous Liberians at the bottom. And there's a way in which both thinking about the early Liberian political project and the Haitian political project, and thinking about what these early Black sovereigns were doing for thinking about both rights claims, both hierarchy and the like, is an important story for us to understand rights, right? So one of the things that we, and rights claims, one of the things that we understand from juxtaposing these two stories together is that rights in and of themselves don't have a substantive or normative value, because rights can be used as tools of exclusion. Rights can be used to further hierarchy. Rights can be used to further power of certain groups. And rights can be used for more emancipatory and liberatory purposes, but they don't necessarily sort of have that. And so there's a way in which rights can be used to aggrandize power of some, i.e. the Americo-Liberian settler class. And thinking about Haitian example of how that early Black Republic was working to help other anti-slavery movements within the Americas, in Bolivia and in a number of other places, which then ended up being hamstrung because of debt to France and a number of other places. So what does human rights do in terms of these foundational narratives? Human rights doesn't engage with these sort of polities at all, really. Human rights constitutionalism is a space where, in the literature, we are to understand rights emerging from thinking about how different domestic constitutions had rights in them that were protecting the rights, and then we move to the international plane, right? So there's like a transplanting sort of theory from all of these different domestic constitutions. The rights get sort of transplanted in the main through imperial realities. And then we move to the international plane to say, okay, well, we should also have something like this at the international level. And so that transplanting story, that story of human rights constitutionalism, doesn't feature, as I mentioned, the Haitian Constitution, the Liberian Constitution, or their sort of rights struggles. So our understanding of global constitutionalism is one that is fundamentally flawed because of this master narrative. And it's important to disrupt both the sites of the dominant sites of understanding global constitutionalism and human rights. And it's important to unearth other polities which had constitutional histories of including rights claims, and the like. And so thinking about South Africa, many might just sort of presume that the 1996 South African Constitution is an example of sort of human rights transplantation, because it's such a new constitution, 1996, compared to sort of other constitutions that are much older. But that would actually be a disservice to thinking about how, again, because Black and other subaltern peoples who were subordinated, either colonized and the like, were not able to sort of make law underneath the colonial powers. And so what they did then was assert claims outside of law. And if we don't look outside the law at a time where imperialism and subordination are at essentially their peak and their zenith, and we're trying to understand rights claims, then again, we're just going to be telling a master narrative that is one of the powerful. And so when we look outside of the law, we actually see that there are many claims that are being made. And human rights methodology does a disservice because fundamentally a right claim is one that you're making that's not necessarily bound by what the law says. You can reach for the ceiling, so to speak. But instead, human rights directs us to what the law is saying at different times, which actually directs us to the floor of what the law will allow, what the powerful will allow, in other words. And so when we look outside of the formal law, we see a number of rights claims that are being made to recognize the rights of peoples, and Clause 1, the Bantu inhabitants of the Union have, as human beings, the indisputable right to peace of abode in the land. And when we look at the substantive claims that are made, is not only that peoples are making claim, African descendant peoples are making claims about being human, because of course they were always human. They're making material claims about the law and political economy. They're making claims about the land, their right to ownership of their land, the right to do things with the land. And so when we think about these claims and we think about how human rights evolved, there's a disconnect between a number of the material claims that are being made about the law and political economy and the sort of hollow claims that we have in human rights now. And so I'll just point to the 1943 African Bill of Rights coming out of South Africa. Of course, there are claims about equality before the law, but I want to point to 5, right? The right to an equal share in all the resources of the country, the present allocation of 12.5% of the land to 7 million Africans, as against 87.25% to about 2 million whites, is unfair. We demand a fair redistribution of the land. So these redistributive claims, rights claims, get completely sidelined and marginalized when we think about the human rights projects, right? So where are the redistributive rights claims within human rights and its development and the like? Human rights can understand equality as sort of a shallow one, which is just about treating people equally, or it can recognize the fundamental and profound inequality within our society that is because of the histories and legacies of chattel slavery and colonialism and the like, and can do something to repair them, to redress them. And so when we look at these sources, we see that there are redistributive claims. There are claims to repair the international order and the national order. And it also points our attention to how long before a number of these claims sort of get taken up formally by the human rights legal regime, there is a recognition of economic, social rights being a priority, and that the role of the state is a foundational one in providing these things, including public health and medical services. I could go on, but because of time, I'm going to move on from here. And so we see these sort of rights claims being made from 1923 to 1943. We see them again in 1955, and they make their way into the 1996 South African Constitution. And this is just one example of how there are histories of rights claims and claim making from African descendant people, which the master narrative in human rights completely obscures and marginalizes, and how these understandings of rights are actually important for a number of issues that we face today around the world. And the other lesson that we learn from looking at these histories is that we have to decenter the role of the state. Human rights focuses so much on the state when the state, in the experience of subaltern peoples, has been the one that has been the place where subordination is coming from, right? And access to the state has been limited. And so what that has meant is that social movements and organizing that is taking place outside of the state in the main, where people are making rights claims, subaltern people are making rights claims, are spaces that we have to look at. Instead, human rights tells us, well, what did the state enact? Well, so what did the state enact underneath racial apartheid? Did it enact laws that protected Black peoples and other subaltern peoples, indigenous peoples? No, it didn't, right? And so quite clearly within the US Constitution, the 3/5 clause and the like, none of those things saw Black peoples as being fully human. But when we look to and understand African descendant and other peoples as thinkers, as agents, as people with ideas about what humanity means and about what rights means, we find so much more. We find a very rich tapestry to tap into. And one of the things that I was struck by is this other source, this Declaration of the Rights of Negro Peoples of the World in 1920. This is the United Negro Improvement Association. This is the Garveyite movement. There is a delegation of over 25,000 people who are meeting in Harlem. And what I love about thinking about this source is that the delegates are meeting and looking at the position of Black peoples around the world and making rights claims based on that. And so that actually flips the master narrative completely on its head, because what's happening here is that the claims that are put forward within the human rights canon are bounded claims, right? The Declaration of Independence of the United States is a bounded claim about the independence of certain peoples within the United States. When we think about the declarations of the rights of man in France, again, those are bounded territorial claims about the rights of certain peoples within the territory of France. When we look at this source, this is a claim about the rights of Negro peoples wherever you find them, not bound by a particular territory, not bound by a particular government. So that means this isn't a civil rights claim. This isn't a claim that you're making just against the state that you happen to live in. This is a claim about rights that are indisputable, inalienable, wherever you find yourself as a Black person. And so that is actually a quintessential early human rights claim, right? And so where is this source? Within human rights scholarship, within the human rights canon? Where is this source within human rights pedagogy? And why has it been completely ignored? I mean, it's so profound, because one of the things that we find when we dig deep into looking at these sources is that there are rights claims that are being made that are particular to Black peoples, wherever you find them, whatever state you find them, that sound in education, that sound in the right to education, and the importance of in education that isn't indoctrinating peoples with inferiority, right? That isn't furthering the master narrative, in other words. And so there's a way in which peoples are imagining an educational system much different from the ones that they are facing, which teach them that they have always been objects, have always been inferior, and have never been thinkers, which is a perverse history that human rights pedagogy and scholarship sort of continues through omission and commission. And we also see that there are meetings of the Pan-African Congress where Black diasporic leaders and intellectuals are meeting between in the early 1900s and 1945, where people are gathering to talk about, again, the position of African descendant peoples within the diaspora across the world, and making rights claims and making demands on the international order. At the very beginning of these conferences, the claims that are being made and the demands are filled with this problematic civilizational ethos, which is like sort of demanding tutelage and is not very far removed from what the master narrative is and those in power would want. But as the Congresses go on, you see the demands for emancipation, for liberation, for independence, getting stronger and stronger, and the demands become more radical. And the claims also sound in the law and political economy and changing the law and political economy. And again, these claims don't feature within the human rights canon. And so what it is important to do is disrupt this practice because it does violence. It does harm. One way that human rights is taught is that there is this generational theory of human rights where, you know, the first world prioritized civil political rights, the second world prioritized substantive equality, the global south prioritized anti-colonial claims, group claims. And when we look at these sources, we see collapsing of this theory. In fact, when we look at the political projects of African descendant peoples making rights claims, we see claims for substantive equality, we see solidarity group claims that are anti-colonial, we see claims for civil and political rights, we see claims for economic, social, and cultural rights, and we see something that actually upends the way in which human rights is taught and understood. And this is important. This disruption is important for today in terms of understanding the challenges that we have today in thinking about questions of repair and redress in the international order. And what we see from looking at these imaginations and these visions is one that is profoundly different from our current material realities and our current legal realities in terms of international human rights. And that gap, and mining that gap, and using sort of the principle of Sankofa and looking back, the Ghanaian principle that you have to understand the past in order to move forward, looking at our ancestors' sort of radical imaginations and building on them towards freedom is an essential thing that we have to do. Our subaltern peoples understood freedom as a place, as a material place that you work to build to, as the work of Ruth Wilson Gilmore has alluded to. And they understood that there were ways to do that in terms of engaging with rights claims. But they didn't think about rights sort of in the abstract. They thought about rights as addressing their material realities. It's important that we think about whether our current human rights regime is addressing the material realities and the challenges that we face in the past, and certainly the ones that we face now. So I'll stop there because I know that I am over time, and just leave my card information up. Maybe I'll just share that while we talk. Yes.
Fabulous. Thank you so much for this presentation. And of course, I had my own thoughts that I had jotted in the margins of your paper that I wanted to talk about, but there are so many other questions that I think are more worthy. So let me just get to them. The first question, from your perspective, how can we address human rights abuses within oppressed communities where internal hierarchies and social racism lead to discrimination among subgroups? Excellent, excellent question.
Oh my goodness, that is a really good question. And I want to actually see you all to the extent that you're revealing yourself. So I'll stop sharing. So yeah, I mean, I think that one of the things that we have to understand, and I didn't talk about this at length, but one of the foundational sort of theoretical frames that we have to engage with is the way in which sort of anti-Blackness is sort of a foundational master narrative. And we can think about other master narratives. But the Black, non-Black binary is a foundational one in modern society. And that means that those who, people are positioning themselves against the Black other. Right. And so it's like, well, at least I am not that, right? At least I'm not African descendant. At least I am not close to the people who were made to be property. And so there is a way in which there is this sort of euphemism of sort of people of color, which can obscure the hierarchies that within the group people have of and at base, we have to recognize not only sort of the anti-Black foundations, but also to the role of white supremacy, right? So there's a way in which white supremacy has functioned, the role of whiteness has functioned for groups to be sort of chasing proximity to whiteness and adjacency to whiteness, which is against Blackness, right? So that means that white supremacy and anti-Blackness has meant that it can be hard to think about coalitional organizing because, you know, one of the tools of colonization is dividing and conquering, right? And so subaltern peoples, instead of sort of seeing our shared ways in which we are not benefiting from the current system, would rather become close to and aligned with the role of you know, racial capitalism and white supremacy, such that coalitional politics and challenging power and racial hierarchies doesn't actually happen, because people are actually invested in the hierarchy because they see themselves as having a more advantageous position within the racial hierarchy. And if you challenge anti-Blackness, that would mean that you'd have to challenge your own position within that hierarchy. And we can think about that through a number of different lenses. I mean, we can think about the ways in which anti-Palestinian racism too is functioning as this place where we refuse to see the humanity of other peoples. And so we don't regard everyone as fully human, right? I mean, the project of human rights is supposed to be about recognizing our shared humanity, but in fact, we are still wrestling with the reality that a number of people still see people as subhuman and lesser humans than themselves or their in-group. And so that is a profound challenge, right? I mean, it requires work to undo and reimagine and restructure a different political ethos and a different understanding of humanity and who is within that. I'll stop.
I can immediately, what came to my mind when I was thinking, when I was reading your paper, were those groups of people who are allowed to have states and those groups of people who are not allowed to have states and those groups of people who can have a state, but it's got limited sovereignty. And so you think about those people who are not allowed to have states. For example, Palestine, Kashmir, those in Western Sahara, those people who are allowed to have states with only limited sovereignty. You think of Japan, and they've got 18 plus US military bases on their soil. So that's an indication of the limited sovereignty. Haiti, of course, has the United States actually selecting its leaders for it. So they have extremely limited sovereignty. And then you have states that are trying to reclaim their sovereignty, like, for example, the Confederation of Sahel States, and they are deemed as possible terrorist states. And that is only because they're trying to reclaim their sovereignty. So this idea of reimagining human rights, not just looking at human rights that we have, but imagining the human rights that we could have had other narratives been able to prevail. So the last question is coming from the dean himself, and he asks, what is it that scholars can do in order to help eliminate this master narrative?
Oh, I mean, I think one of the things we're doing is we're doing it now. And so first, before I respond to the dean, I want to just respond to you, because one of the things that we found, and I love Saadia Hartman's work, this literary scholar and cultural historian, but her analysis of sort of the double bind of freedom, which is that essentially we have a burden individuality as Black peoples. And what I'm thinking about is extending that to thinking about subaltern peoples as having a burdened independence, right? A burdened, where we have sort of a shallow, etheric victory of independence, right? That masks the fundamentally inequitable, exploitative, and hierarchical nature of the international order, where a number of peoples are actually not even still considered sort of sovereign and able to govern themselves. And even those who are considered sovereign and independent states, as you just rightfully said, that sovereignty is sort of in name only. That equality is in name only because the reality of geopolitical hierarchies are such that these nascent sovereigns were not really able to flex. We're not really able to take advantage of what sovereignty is supposed to provide in terms of control over your resources, disrupting histories of extraction, and countering your material reality. And there was a moment in time where those newly independent states sought to organize a new international economic order, right? Which was trying to reshape the world in a fundamentally more equitable way, to repair and redress the centuries of foreign occupation, colonial domination, and apartheid, which called for restitution, which called for full compensation for the exploitation and depletion of damages to natural resources and all of the resources of those states, territories, and peoples. And instead, those claims were never materialized. We have centuries of exploitation and extraction and unjust enrichment that has gone unrepaired. And when you call attention to that fundamentally unjust world, it is as if you are refusing to quote unquote move on, as if the past is not present, as if what has happened is not still rebounding in terms of legacies of inequities. And so thinking about what our role is then in the academy is that we have to disrupt. We have to disrupt these narratives. We have to change the sources that we rely on. We have to change how we teach human rights. We have to change our understanding of what it means to be human. We have to do the work of knowledge production and move beyond sort of pedagogy that is for the academy, but thinking about a pedagogy of the oppressed, really, right? So we have to think about education that is furthering our emancipation as subaltern peoples around the world, and that is actually doing the work of undoing our conditioning, right? Our conditioning has been so conditioned that we can't even see the condition, that we can't even see that our imaginations are bounded, that our realities have been constructed, which means that they can be unconstructed, right? That the choice for things to be as inequitable and as profoundly unjust as they are is because millions of us, billions of us around the world continue to accept our present reality. And so the work in the academy is to contribute towards disrupting that narrative. We have to do that. We have to do that because that is the only place that we then can think about imagining a different today, imagining a different tomorrow, and then working to do that. And partnering with others to do that, to create the world which we want to see, and which requires repair, requires redress for chattel slavery, for colonialism, for genocide, which were in the past and which are ongoing. And these are the things that we have to do. So even when we think about what are the sources that we use to teach, disrupting the sources that we use, thinking about how we are not relying on sort of international treaty law, because recognizing that the role of law oftentimes as it relates to subaltern peoples is not a liberatory one. So when we teach the whatever the positive law is, we also have to talk and have conversations about what is not reflected in the law, what are the other claims that were made that we don't see reflected in the law, why were those claims not reflected into law? And think about the role that power is having in constructing our understanding of what is legally possible. And capitalism is having in constructing our understanding of what is possible as well. So our role in the academy is to train others to be disruptors of the master narrative in whatever space or field that they found themselves in, and wondering, I mean, my own project is like, well, where are the African descendant peoples? I mean, I know they were there and I know they were doing things, so where are they? And we have to think critically in whatever space or field that you find yourself in, and then start asking questions and then start digging and sharing. That's our work.
Dr. Soli, thank you so much for your thought-provoking remarks this evening. And to our audience, I would like to leave you with one question to ponder. How do you privilege the already privileged in your own life? So with that, I would like to say thank you, Dr. Sirleaf. We will definitely hear more from you. Hope to see you on the North-South University campus one day too.
I hope to be there. I wanted to say, I hope that this conversation can happen in person one day, because I would love to continue to be in conversation. And also, I want your notes. I'm not joking. I want the notes for this article so that I can help to revise it. So please send that to me and anybody else. Please, let's be in touch.
Absolutely. So thank you all. Thank you to the audience. Thank you, Dean Rizwan, for inviting this dynamic guest. And with that, we will sign off. Bye, guys.
Thank you so much. Take care.
Thank you. Thank you so much.
Okay.
Have a good day.
Thank you.